Today, let's talk about destruction of records and the following risk of being criminally prosecuted for obstruction. Let's talk about how civil tax problems can turn criminal on you if you're destroying records. Destroying records during a tax issue is not damage control. It's often the fastest way to turn a civil tax problem into a criminal tax case. Many taxpayers simply don't realize this. They think deleting emails, discarding documents, or cleaning up files will reduce criminal tax exposure. In reality, it often does just the opposite. The IRS and state tax agencies expect business records to exist. When records disappear after an audit begins, or is reasonably anticipated, or a criminal tax investigation, these are huge red flags, not because of the underlying math of the tax fraud, because of the implication of criminal tax intent. Once criminal tax intent is inferred on your actions, the focus in your case completely shifts. It shifts from straight-up tax compliance to tax crimes, including the crime of obstruction. What qualifies as destruction or obstruction? Destruction doesn't require shredders or fire. It can include deleting emails or texts, altering spreadsheets after the fact, backdating documents, losing digital files, instructing employees to discard records, recreating documents after the fact. Even partial destruction or selective preservation can matter, especially when all of this takes place after IRS or state taxing authority contact. Timing is everything here. Timing changes everything. Actions taken before an audit, inquiry, or criminal tax investigation are evaluated very differently than actions taken afterward. Once an audit or criminal tax investigation starts, or is reasonably expected, the rules change. And I'm not telling you to delete stuff before it happens. At this point, ordinary record management can look like intentional concealment. The risk here is not limited solely to the IRS. California agencies coordinate amongst themselves aggressively. The Franchise Tax Board, the California Department of Tax and Fee Administration, California Employment Development Department. Each of these California agencies has independent authority, but they share information amongst themselves. One California agency spotting obstruction can trigger multiple agency criminal tax escalation across the board. Civil penalties can stack up on you at best. Criminal tax referrals can follow at worst. Here's why CPAs, EAs, and CTEC preparers alone can't protect you in this situation. Here's where many cases collapse. Taxpayers relying solely on a CPA, EA, or CTEC certified tax preparer. Their communications with these folks are not privileged. In criminal tax matters, their emails, their drafts, their explanations, their work papers are all discoverable. And once these records go missing, those communications often become the roadmap that turns a civil case into a criminal tax investigation and prosecution. So what's the correct strategy here? If you have records that are incomplete, missing, you're at risk. The solution is not improvisation, it's controlled response. That means you need to hire somebody with attorney-client privilege, work product privilege, and you need a risk assessment done before disclosure of anything. You need coordinated document handling. Strategic communication timing is very important. This is how civil cases stay civil. So in closing, if records have been altered, destroyed, or mishandled, and you find yourself under audit or criminal tax investigation, don't try and explain this casually. Don't try and fix this yourself. Talk to a dual licensed tax attorney and CPA like myself. Do that before the situation escalates criminally. Call the tax law offices of David W. Clausing at 800-681-1295 or visit clausing-associates.com to schedule a confidential, reduced rate initial consultation today. You won't regret it.